Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. Hey, Maeve. How are you, my dear? Regarding CE, actually confused, annoyed by the CE reports as he indicated no issue. Even lied about non-subjective things. I can stand and walk on toes and heels was a bold lie. And we have, I don't know if you've seen him, Maeve. Obviously, it didn't matter for your purposes, thank God. But yeah, still approved. So yeah, it is interesting. Sometimes if the case, sometimes like you see a report and you're like, that is BS. I mean, let's say they never even had you do walking on the toe to heel and he said you could do it. I've seen things like that with person like, they didn't have me do that. Or they say, I've talked about this before, guys, at a CE, they never, you're alone in the room when they say, okay, get into this gown or get up on the table, whatever. You do it in whichever way you can manage it. Don't know if you had to like huff and puff or roll on your side to get up there because of you can't do the old leg, like whatever, or can't do the hop up. I've seen where it'll say they had no, in the report, no problem getting on the examining table. And the person, my client will say, they weren't in the room. I did get up on it. It was difficult, but they weren't in the room. They'll also say, no difficulty undressing to get in the gown. And again, when is that ever done with anybody in the room? And they don't have cameras in there. So you see these, I think it's because they have canned reports and they just leave it all and they only change a few things. And it's therefore defamatory, dare I say it. And because it's untrue and it can financially damage you significantly if the SSA choose to embrace it. So what we do then, and this is only if the case doesn't go south. So like Maeve, case didn't go south. Sometimes you shut your mouth until you see if the SSA is going to give this BS any weight. You wait patiently while you angst about what it says, and then see if everything else that has been done on the case, all the arguments, all the, connecting the legal to the medical records that exist from treaters, does that all conjoin so the SSA does not give weight to their CE person? And that, as you can see, is probably a wise strategy. Versus rocking the boat. I won't rock the boat on my people when we're still waiting for the answer. If the answer goes south, then I start burning everybody who participated in it. You know what I mean? I'll call out that CE and I'll report them and say, this is what the client says. Never did this, and this. Falsely reported in that report over there. Ba-boom. What the SSA does with it, I don't know. I mean, where are their sources on investigating that kind of stuff? I know they've limited investigation sources, but I don't know how much you have to investigate it. You can actually look, they already know that they didn't go with that person's opinion, right? So anyway, it's good to see you, Maeve. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hello. Okay, so it is Thursday. Thank you for someone just reminding me of that. I think I thought it was Wednesday. All right, so I'm just going to address a question that came to me today. Super fast. I have a little break here and thought it would be fun. So it concerns consultative examinations. And if you have the, you ultimately get a copy of the report sometimes. If you have an attorney, they would have a copy. They would be provided a copy in time now that we have access to the electronic file. And that attorney could obviously share it to you. So the question was, what recourse do you have as an applicant when the physical consultative examining doctor, the words are blatantly lies on the patient's medical report? So, okay, it can be a blatant lie or it could be an untruth, but without the intent to lie. So I'm not going to go into whether something is a lie versus a complete inaccurate statement of which there is no basis. Either way, the result is the same, right? The intent isn't really at this juncture, anything you can actually prove. So it could just be a major screw up. It could be a completely incompetent provider. So, look at it from that perspective. So what do we do? If you see, this is what I would do. If you see now not a discretionary finding, it's got to be something that is absolutely false, such as, he did range of motion testing, moving this, moving that, or having you move it. And he commented on, any kind of restriction or non-restriction, no restriction. That would be a complete inaccurate statement all the way through, because if he never actually did the range of motion testing on you, which, is a little bit of manipulation perhaps of your body part, then clearly there could be no appropriate discussion in his report about what the results were, right? So if that were the case and I see it, I would probably want to document for the SSA in a respectful, polite manner. And by the way, if you have an attorney, maybe it should go through your attorney. Always go through your attorney first. But this is what I would do as an attorney. I would, first and foremost, if the report is favorable anyway, and you're probably not going to know if it is necessarily, you might see things that are wrong. But if certain things are actually in your favor, wrong or right, that can be something. If the SSA decides to put a lot of weight on the consultative examination report, and by the way, it doesn't have to. I see plenty of times on initial recon where the ultimate finding is that the CE examination was an overestimate of the limitations. That would be where they're not going to follow them so they can deny. I've seen other ones where a CE examination report was what we would consider helpful. And that's a technical term, because you might see things that you think are helpful and they're actually not helpful for your case, because it all depends a lot on your vocational profile. A finding of, X limitation for one guy is going to have a different effect on his case than for you, because for a variety of legal reasons. Okay. And it all depends on so many other factors. So what you think you're seeing, you might not actually be seeing the actuality of it. But, if you do see, if you are sure it is a unhelpful report, and again, you're not going to know that if you don't have the legal background. You're just not going to know it, probably, most of the time, by and large. But if it were to be a negative report, and it's something that you definitely want to knock down, you can submit a letter to the adjudicator. It's probably not going to give it any weight whatsoever, but it'll be documented then in your file as to, he said he did a range of motion testing and he did no such thing. He never touched my shoulder, never touched my knees, my legs, whatever. If you see something in the report, such as patient was able, or the claimant was able to get onto the table without difficulty, and let's say you never got on the table when in the view, maybe there was nobody in the room when you got on the table, then how on earth could they say that? That's something I would refute and say that's, in some way, shape, or form. Again, and when you refute, I would do it very respectfully, professionally. Even if you're not a professional, you don't want to necessarily be coming off untoward in any way. And that's why I would prefer that your lawyer do it for you. What are some other examples? If he says that you said something you didn't say, you could say, this statement was never made by me. Perhaps he's mixing me up with a different claimant. I also wouldn't go off saying he's lying. I would say there are untruths in that report. There are inaccuracies in that report. There are statements that are untrue in that report. That is not the same as calling him a liar. A liar means intent to, falsify something. And that's not necessarily the case. And even if it is the case, you can't prove it. So now you're going to get defensive mechanisms coming up, and you don't want that. I don't think that'll be in your favor. The reason why you might want to point out actual objectively false things, like he never did a range of motion test, or he never asked me that question, I never gave that response, either one of those. The main reason is that if you end up going to hearing, and if once you're going to hearing, you can see what the SSA weighted and how they found that you were not disabled, can't really see that before then. So once you go to hearing, you can get access to that. And if it's shown that the SSA relied on that consultative examination as part of the reason why they denied you, some of those findings they relied on, for a finding of not disabled, then it would be important to point out to the judge why it shouldn't be relied upon, right? So that he doesn't do the same thing. He has the power to not do that, he or she. I mean, he doesn't have to conform to any finding that the SSA made. He can make his own decision. So that would be a reason why I might point out. And the fact that you pointed it out a year ago when it happened gives it a little bit more probably reliable persuasiveness. The fact that you're saying it in real time, it went to the SSA, not to the judge. but the judge is later, it's later going to be in that file, or should be, when the judge gets it. And he's going to see that you said that a year ago. You're not just saying it now at the last minute when you're worried about your hearing. You see what I'm saying? You're saying you're bringing forth a document that was done a year ago in real time when the hearing was, when the examination was fresh in your mind. That's when you did it. I think that lends itself to the fact that it's not an unfresh recollection, and that you might be subconsciously pulling it out of your backside because you don't like the results of the CE. It shows that at the time, this is what was going on. Let's see what else is in this question. Well, one of the issues was the CE examining doctor said there was no medications and side effects. And if you did tell him that there were medication side effects, that would be inaccurate for him or her to say that in the report. So that is something you could say. And again, respectfully, he must not have heard my answer when he asked me about medication side effects, because I did tell him about X, Y, and Z, but he erroneously, because erroneously is not saying lying, it's saying erroneously. I'm losing my voice. And, there was no side effects. I would add as a side point, your medication side effects should be elsewhere in the record anyway. You are asked about them on your function report. So hopefully you didn't get lazy on that and not include them. Sometimes people will put that there's no side effects because they don't realize that some of their symptoms may actually be side effects. So I always recommend, so again, this is a side point. If you're doing your function report and in the part where they ask about side effects from medications, take your medication, each and every one of them, look them up on a website such as drugs.com. There's a few of them, and go right to the link for side effects. Look for the common side effects. I wouldn't be looking for the severe ones, because if those happen, you probably would have hospital records pertaining to that are already in the record. But the common side effects that no one really talks about, they can affect certain jobs and make them off limits. So you want to include those. I would be doing those, looking at the list and deciding which of those symptoms do you have. You're not a scientist or a doctor. You can't say for sure whether it's from the medication. It doesn't matter. Put it in there. You have this symptom. It could be from the medication. No one ever is going to know for sure if it's from the medication or from something else. I mean, let's say you have joint pain, but one of your medicines causes joint pain. And, one of your claimed impairments in your case is joint pain and limitation. Are you not going to put joint pain as a side effect of the medication you take that actually often, because it's a common side effect, causes joint pain just because you had it before you took the medication? I would put it on there because it might be lending itself to additional joint pain, maybe more frequent joint pain. Maybe it's more durational. The point is you have that symptom, and that happens to be a side effect of medications too. So I would put all those kind of things down, all the side effects. Anyway, if you did that right, and the CE examiner said no side effects, even though he either didn't ask you about medication side effects, which might be pretty common because they like to rush through these exams, right? Or he misstated what you said, that could be something you put in that letter. Again, respectfully, just like this was erroneous. This is what happened. Let's see. Oh yeah, right. On and off the exam table. We already went over that one. That's a biggie. And if let's say he was in the room when you got on and off the exam table. And often, when we go in a doctor's office, we get on it when they're not there. We're waiting for them to come in, right? I've seen comments about had no difficulty dressing and undressing. Who's in the room when you're undressing and dressing? To me, that would be a false statement because he has no idea. Now, of course, if he asked you when he came in, hey, did you have any problems undressing into your gown? If you got into a gown and you said, no, doc, no problem. Well, then that's why he's saying it. And that's probably not going to be a problem. But if he never asked you, and if he wasn't in the room when you did it, and I would think that would be the majority of the case, it just seems like that way. Like, nobody's in there when I'm undressing, that's for sure. Then how on earth could they say that? So that is something you can bring up. Most people with physical problems, and this is a physical CE exam, if you have physical problems, and this comes up under function report number 12, when they ask any problems, it's about dressing and bathing and feeding yourself and shaving and doing your hair. And people often just leave that, check off no problem. And I'm like, you're claiming you can't twist, turn, bend because of a bad back. You're saying there's no effect on your ability to change. I mean, when you were 20, you used to whip in and out of those clothes. We used to get dressed super fast, bend over, tie the shoes, blah, blah, blah. You're saying there's no difference now? You can do it just like that? Never have I seen there not be an effect once the person's questioned, where they actually understand what the question is now. And so the same would be true in here. I would expect that when you're dressing, maybe if you have a physical impairment, it's probably going to be, for most physical impairments, a little more slowly you dress. Maybe you're careful when you're bending. Maybe you sit down and you put on socks, pants, and shoes, because otherwise you're going to fall over. So many differences. But anyway, that's another thing to look at. And yes, I would put that in there too. But again, in that respectful tone, Make it, don't act like you're inflamed by the doctor and you don't like him. Okay. It's not your personal feelings that are at stake. It's the accurate and inaccurate statements. Listen, what else? Yeah. No exam table in the room. No exam table in the room. And they said he could get on and off the exam. I think what happens here is they have a canned report and they click whether it's yes or no. And then the sentence goes in. And like any other kind of canned thing, there's default sentences that really, this is sloppy and lazy, but I think that's probably what's happening here. They have the list of the sentences that are going to go in. And if they're not paying attention, they are leaving things in that are inappropriate. So I would do a letter, and at least it's in the file. And then when it gets to a judge, and or if you have to go past a judge, that's in there. It's not made up at the last minute or what have you. Let's see. So again, you can't demand that the SSA get rid of the report, but your letter might have them apply less weight. And it might not happen at that initial stage because they tend to be more robotic, more checkbox-ish, particularly when it comes to denying. So it would really be something that's probably going to be more, if it's going to be effective, it's going to help you later. But that's what we do. It's like what we do now is to not only address what's needed now, but even if we know something's not going to be looked at now, because we don't have a judge who is usually a lawyer looking at it now. We have a non-judge person, sometimes a very new, unskilled, poorly trained or little trained, or not enough, not enough time working in the environment to actually learn, well, what they're supposed to be doing. So, I just think doing it now is for later, usually. And who knows? It could be, you're not going to know certain numbers they give in those reports. You probably don't know if it's a good or bad number. You think you know, but you might not know. Because again, the number will vary depending on the claimant's past work history. Because whether or not that number prevents old jobs, and everyone's got their own set of old jobs. So every case is different. There are generalities, but there's too many. You don't know which one you're going to fall into. So that's your vocational profile, which is super, super important the entire way through your entire SSA process. We probably have some sort of video on vocational profile. If not, I'll try to get one out. But for sure, I would do a letter. I would go through the lawyer, make sure, speak to him about it. He might have a different take, but something very egregious. Yeah, maybe just do a soft little documentation to the file that they have. Don't expect any results on it now. Frankly, if your own doctors had done decent reports, they wouldn't have sent you to the CE exam. So there's plenty of blame to go around as to why you're not prevailing if you're actually disabled. That's a fact. SSA doesn't relish the thought of spending money on a consultative examination. They're poorly funded as it is. It's because your doctors have not, either you haven't been treating enough, or they're just doing a very typical, unfortunately, job of poorly documenting your day-to-day struggles that you hopefully have told them about. So take that with a grain, all of that with the CE exams. I would probably do a letter, but I would do it with the lawyer's assistance. And you don't necessarily want to do it if that examination report is ultimately going to be helpful to you, because there is some great nuggets in there. And again, you're not going to know this. That's why it's really important you confer with your attorney. Okay. He's going to know which ones help you, and if nothing helps you. And if nothing helps you, then perhaps he'll be like, yeah, let's send in a soft letter. It'll just kind of paper up that issue in the file. So when we get to an ALJ hearing and we don't think the ALJ should be embracing this consultative examination as part of his decision, we'll give him a reason why not. All right. Ciao, guys. Thanks for the question. I appreciate it. Bye now.